We are here both in public and televised tonight, and we have to start off with the Commissioner of Canada Elections, Mr. Côté. Mr. Côté, will you introduce your guest? And I understand you have an opening statement.
Indeed, sir. Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chairman. I do indeed. First, I would like to thank the committee for giving me the opportunity to testify today regarding the proposed changes by way of Bill C-23 and its impact on my role as Commissioner of Canada Elections. I'm accompanied this evening with our Compliance and Enforcement Senior Counsel, Ms. Audrey Nowak. Before discussing the bill per se, I think it would be useful to the committee to remind them why the position of Commissioner of Canada Elections was created in 1974, 40 years ago, and placed within the office of the Chief Electoral Officer.
But it should not be involved in prosecutions under the Canada Elections Act. Such prosecutions, to quote the Attorney General of the time in 1974, should be the responsibility of the Chief Electoral Officer whose independence or independent position could not be questioned, according to the Attorney General at the time. At the same time, the Chief Electoral Officer was concerned that his own involvement in the investigation and prosecution of election offences could be seen to diminish his impartiality. So this led to the creation of the position of Commissioner for Canada Elections in 1974. The position was placed within Elections Canada so that it would be fully independent from the government. The mandate of the Commissioner initially was confined to offences involving election expenses, but was later broadened in 1977 to include the enforcement of all election offences, including prosecution. With the creation of the Office of the Director of Public Prosecutions in 2006, election offences are now prosecuted by the DPP. Let me now turn to my comments on the bill that is currently before you. Et le premier point que j'aimerais aborder porte sur les changements.
First point is on organizational changes which are called for in the bill. Bill C-23 proposes to go much further than what was done in 2006 by placing the Commissioner within the Office of Director of Public Prosecutions. And as you are considering this proposal, I think that I would ask you to consider, it's important, to understand the benefits of the current model, which, in my view, strikes a proper balance between investigative independence and a coherent and informed application of the Canada Elections Act. Indeed, I must stress that as Commissioner, I have enjoyed complete and unfettered independence with respect to the conduct of investigations and the choice of enforcement actions, including the decision to refer a matter to the DPP.
And there has never been any attempt by the Chief Electoral Officer or by anyone at Elections Canada to interfere in any way with the manner in which I and my investigators do our work. In other words, and I think it's important that I should state this, I alone, as Commissioner, decide what to investigate, how to conduct my investigations, and what measures are to be taken, including, again, possible referrals to the DPP. At the same time, my presence within Elections Canada allows me to have direct insight into how the law is administered and also to understand the main challenges faced by Elections Canada with respect to compliance. This informs my interventions and reduces the risk that regulated entities, such as political parties and candidates, be caught between conflicting interpretations of the rules. The need for such coherence explains why, to my knowledge, in the vast majority of regulatory regimes, the administration and enforcement of the rules are vested in the same agency. Examples of this would include the Canada Revenue Agency, the Competition Bureau, Fisheries and Oceans, and the Canada Border Services Agency. This, by the way, is even true, for example, of the CRTC, which, under the very terms of Bill C-23, would be granted the mandate to administer and enforce the rules on what is referred to as voter contact calling services. À mon avis, si l'on sépare le commissaire d'Élections Canada,
in my opinion, if we are to split my job, in order to avoid this situation, I think it's important to preserve the ongoing relationship between the two entities. This goes beyond transfer of information in support of investigations, something which in fact isn't covered by Bill C-23 explicitly, and for which would require amendment to ensure timely and effective investigations. It also means that the two entities, Elections Canada and the Commissioner's Office, would need to create structured mechanisms to continue to work collaboratively. For example, we might consider the establishment of a joint committee on regulatory compliance in order to discuss trends or new issues that may arise as a result of evolving practices by political parties and candidates. Moreover, given that the Bill C-23, political parties would be able to request written opinion from the Chief Electoral Officer on the application of the Act, that these opinions would be legally binding on the Commissioner, there need to be mechanisms for consultation between the Commissioner and the Chief Electoral Officer.
3 would bring under the same roof two functions that are normally, and for good reasons, kept separate. This structural change raises important questions with respect to the separation of the investigative and prosecutorial functions, a separation that was deemed sufficiently important in 2006 to remove prosecutions from the Commissioner. It also raises concerns with respect to at least the perceived independence of the Commissioner from the government of the day. Bill C-23 provides that the Commissioner's investigations must be conducted independently of the DPP. I do have, of course, every reason to be confident that neither the DPP nor the Attorney General would interfere in my investigations. However, the fact that the Commissioner would be placed within the office of the DPP and that the DPP reports to the Attorney General on the Commissioner's activities does, it seems to me, present challenges, at least in terms of perception. For all of these reasons, Mr. Chairman, I do not think that the proposed move to the office of the DPP is a step in the right direction.